Today, I'm joined by Mr. Ilya Shapiro. He is the director of the Robert A. Levy Center for Constitutional Studies at the Cato Institute and is publisher of the Cato Supreme Court Review. He is an attorney and author of the new book, Supreme Disorder. How are you doing today, Mr. Shapiro?
I'm doing all right. It's a pleasure to conclude my week by talking about my book.
Oh, well. So I just have a couple of questions for you today. It's just going to be a short interview. I know you're a bit short for time, but get started whenever you're ready.
Go ahead.
Okay. So could you start by telling me a bit about yourself and the kind of work that you do?
Sure. So I run the Constitutional Law Center at the Cato Institute, which is the nation's largest and foremost libertarian think tank, public policy organization, which means that we produce research, media appearances, and otherwise try to influence the climate of ideas on a broad range of policy issues, ranging from education and healthcare to international trade and foreign policy to my area, constitutional studies, which means that my department files briefs with the Supreme Court and sometimes lower courts. We publish academic articles, we publish policy papers, op-eds, blog posts, tweets, and my colleagues and I also go around the country or during the pandemic virtually debate law professors or give public speeches, again, trying to move the climate of ideas in a more classical, liberal, Madisonian, libertarian direction.
Oh, you're doing good work over there. So then what would you describe yourself as politically? So you do work at the Cato Institute in DC, founded 1974 by Edward Crane, Charles Koch, and Murray N. Rothbard. Traditionally, Cato's advocated for, like, as you said, positions that are considered economically right-wing, socially left-wing. Therefore, would you consider yourself as being something of either classical liberal, libertarian, small government, constitutional conservative?
Yes.
One of those? Yeah.
All / some of the above. Yes.
Okay.
Classical liberal, I guess I prefer. I'm also a bit of a contrarian. If I'm in a group of conservatives, I'll be the libertarian. If I'm in a group of libertarians, I'll be the conservative. I'm sort of a big tent kind of guy. I'm one of the rare libertarians, if you want to call me that, who doesn't apply purity tests, because typically, libertarians have a purity test where that individual is the only one who qualifies as the one true libertarian, or the one true Scotsman, as it were, to use the analogy. So I'm just for working with whoever wants to work with me on the ideas that I believe in.
Yeah, no, that's generally something that I've noted. Libertarians generally tend to fight more among themselves than with than against, for instance, like the mainstream left or the mainstream right, unfortunately.
Yeah.
So now, Supreme Disorder. Could you explain a bit what your book's about? I know it's more or less about the issues that well, personally, I haven't finished it yet, but it's more or less about the issues that currently pervade the modern high justice system. But what topics do you generally focus on when presenting your overall thesis?
Well, let me begin by telling you how this book started.
That was going to be my question after this. Yeah. Okay. Yeah.
In the wake of the Kavanaugh confirmation hearings just over 2 years ago now, clearly I found that the Supreme Court had been enveloped in the same toxic cloud that the rest of our public discourse was in. And I thought, how did we get here? I knew the story starting with Robert Bork, say 30 years earlier, 1987, when he was rejected by the Senate. And it's sort of from there, there's been a ratcheting up of tensions over judicial confirmations and disputes over who started it and when and who's more to blame and all this, now filtering down into battles over lower court judges as well. And I thought, well, when did politics become such a big part of judicial nominations? And what can we learn from the last however many years that are relevant? And where do we go from here? And as I went about doing research for this book, I found that perhaps not surprisingly, politics has always been a part of judicial nominations and confirmations, because after all, even in George Washington's day, the president was a politician and senators were politicians, and they had their various concerns. And certainly the decision of whom to nominate for judgeships or for the Supreme Court is a political decision, and whether to vote to confirm or reject is a political decision as well. And that's played out differently over time as different concerns in our republic's history have come to the fore. What's different now is that you have the culmination of several trends. First of all, power has become gradually centralized in Washington, and within Washington, it's become skewed to the executive branch, meaning not just the White House, not just the presidency, but the administrative agencies and departments that write the rules and regulations that by which we live our daily lives, much more than the laws that Congress actually passes. And so the Supreme Court is ruling ever more on the major political controversies in our life. So that's one dynamic, the power shift, centralization, and skewing within the federal government. And at the same time, you have divergent interpretive theories of constitutional and statutory interpretation that map onto partisan preferences at a time when the parties are more ideologically separated or sorted and polarized than they've been since at least the Civil War. So, of course, when you have these precious openings in this very powerful high court, or even the lower courts, because the Supreme Court only decides, 70 cases a year, the lower courts decide 50,000. Of course, there are going to be these zero-sum game fraught battles over these seats. So that's how we've gotten to where we are. And all the politicians are responding to the incentives that they face given the dynamic that I've just outlined.
Okay. So that's okay. Yeah, that was okay. Yeah. At what point do you feel that things really started to go awry in our justice system? And what particular Supreme Court decisions do you feel were most detrimental to the rights and civil liberties of Americans overall?
I point to 1968 as the beginning of the modern age of judicial battles. Now, a lot of people point to Robert Bork, as I mentioned, 1987, but I think the story doesn't start there. That was kind of a lot was going on below the surface, or the Bork happened to be the first nationally televised gavel-to-gavel confirmation hearings, because coincidentally C-SPAN happened to get access to the full Senate that year before they had access to the House, and C-SPAN only started up in the early 80s. But 1968, as in our cultural history and our political history, I think is a key date in our legal history, because that was the year when Chief Justice Earl Warren, who himself had been a controversial figure, and the court that he led to a lot of political controversies in the 50s and 60s. But he announced that he was retiring, and President Lyndon Johnson, announced that he was elevating Justice Abe Fortas to become Chief Justice. And that ran into a buzzsaw, in part because of Johnson's unpopularity, right? He would announce that he was not running for re-election. He was too bogged down in Vietnam, was unpopular. But Fortas himself was seen as a crony of LBJ's, at times going to the White House to help advise on bombing campaigns and what have you, but also had some ethics issues, had given a series of speeches, and he didn't disclose that he was being paid for those. In any event, he faced bipartisan opposition in the Senate. Some people call it the first filibuster of a Supreme Court nominee, although it didn't get to that kind of a vote, and he didn't even have a majority of support, let alone a supermajority to break a filibuster. But anyway, that failed nomination in 1968 led to Richard Nixon, who campaigned on taking the court in a different direction, talking of law and order and strict constructionism, which eventually became originalism in later years. That's really what pivoted to our discussion, to the use of judicial philosophy as an important criterion in deciding what kinds of nominees to pick, and
so
whether
things like precedent and judicial activism.
That's right. That's right.
So just to move away just from your book for a moment, this is really relevant to what's going on right now, especially with the current political divide we're in. A number of Democrats have been talking lately about packing the courts, which is resurrecting an idea that was first floated around by FDR back in the 1930s and 40s. How do you feel about that particular proposal, and what do you think the purpose is behind its support, particularly on the left?
Right. Well, there's a perception among Democrats, and especially among progressive activists, that the Supreme Court is illegitimate, and specifically the last few Republican-appointed, Trump-appointed justices are illegitimate. Kavanaugh, because he quote unquote stole Merrick Garland's seat. Gorsuch, because he stole Merrick Garland's seat. Kavanaugh, because of his sexual assault allegations. Amy Coney Barrett, because the Republicans rushed to confirm her after Justice Ginsburg passed away less than 2 months before the election. Others on the left would say that Roberts and Alito are also illegitimate because they were appointed by George W. Bush, who wasn't legitimately elected in the year 2000. So there's a lot of kind of built up frustration and polemics on the left. And so the remedy that was proposed, one of the remedies, is to pack the court, to appoint as many justices nominated by a Democratic president as would rebalance the court sufficiently. The problem with that is, yes, there's a parallel to FDR in 1937 when, having been reelected in a landslide in 1936, he won all but 2 states in the depths of the Depression. But he was frustrated that a lot of his New Deal programs were being rejected by the Supreme Court because the so-called old men weren't up to the job, is what he argued. And he wanted to add a new justice for every justice that was older than 70 and a half, which would have conveniently added 6 justices and given a working majority to more Democratic, pro-New Deal, pro-FDR type jurists. And this was very unpopular. His own vice president, FDR's vice president, came out against it. The court, the key justices, including FDR's supporter and advisor, Louis Brandeis, came out against it. And the Democrats in the 1938 midterms ended up losing 80 seats in the House and 8 in the Senate over it. It was seen as being too politicized, unpopular.
So is that when, sorry to interrupt, but is that so when they lost all the houses or all the seats in the House? Is there a correlation between there and sort of the rise of the conservative, like the conservative movement, like the precursor to the conservative movement now?
No, not really. The
Okay.
Democrats had such a supermajority going into that year that they still maintained their majorities in both the House and the Senate.
Okay.
They just didn't have I mean, at one point, I think after the 1936 election, the Republicans were down to, I think it was 90 something seats in the House. So it was really a rump. And things, Democrats maintained their majority, but just not quite the huge supermajorities. But that was the latest example. But in our history, we have had different numbers of justices, as low as 5 and as high as 10. Although it got fixed statutorily. This is by act of Congress. You don't need a constitutional amendment to change the number. But we've been at 9 since 1869. But each time that number changed, there was a political reason for it, and it didn't necessarily inure to the benefit of the party proposing the change, let alone the country more broadly. So I think there's a similar dynamic going on now, which is why the more moderate Democratic senators, notably Joe Manchin of West Virginia, who's now seen as the most powerful man in the incoming 50-50 Senate, right, with Kamala Harris, the vice president-elect, to live in the Senate, to be the tiebreaker. But there's not as much appetite to, first of all, get rid of the filibuster in order to pass a legislation to expand the court. And Biden himself, who during the primaries was against court packing, as was Bernie Sanders, by the way, this is possibly the only thing on which I agree with Senator Sanders. He said, look, I'm not going to do the accent, but he said, look, if we do this, then the next time Republicans are in power, they're going to do it. And in 50 years, we'll have 87 justices. It's just no good. And I think that's right. So
exactly.
Biden said later during the general election that he would appoint a judicial reform commission, a bipartisan commission, to look at whether structural reforms or other things to address questions of legitimacy or whatnot. I think the most realistic thing out of this commission, normally presidents appoint blue ribbon commissions to kick a hot button issue down the road when hopefully there'll be less heat on it in 6 months or what have you. But I imagine to the extent that these experts, if they're truly representing a wide array of opinion, the only thing they might be able to agree on is to expand the lower courts, because we haven't had new lower court judges added. I think district court since 2002 and circuit court since 1990. And given the growth of litigation, number of cases, just based on the growth of the population, there is a need in many places to add lower court judges. And I think politically it's doable as long as you stagger them, that some of them are added, every 2 years at some point in the future when you don't know exactly who's going to be appointing them.
Okay. So what is your assessment on the current members of the Supreme Court? Are they generally beneficial to the advancement of liberty, or do they represent merely just a further degeneration of our justice system? Not to make that sound like a loaded question or anything, but
I'm not going to go through each justice and kind of give them a score on different areas of law. Okay. I will say that you can see a lot more variety of jurisprudential theories and applications from the Republican appointed justices than the Democratic appointed ones. People like Sheldon Whitehouse, senator from Rhode Island, likes to talk about the Roberts Five as if there's a cabal to undermine the Constitution or serve the interests of corporations. And
I've seen like a lot of, the funny thing about that too is there's a lot of people I've noticed on the right who talk about the exact opposite, and like, oh, Roberts is like a hardcore liberal, basically. And it's just,
well, that's a different issue. He's been trying in the 2 years when he was the median vote after Kennedy was replaced by Kavanaugh. He was really trying to kind of tack back and forth to try to make the court seem less political. I don't think he's particularly successful in doing that. No. But anyway, the thing is, the suggestion of a Roberts 5 implies a Ginsburg 4. And I've done statistical analysis of this, and the Democratic appointed justices stick together a whole lot more than the Republican appointed justices do. And you see this in all sorts of different kinds of cases. And you see that, on the right, some are stronger or weaker originalists. Some care more about judicial restraint than legal theory. Some are more law and order types. Others, it's some use prudential factors more. There's differing views on stare decisis, the strength of precedent. So there's a lot more intellectual, I think, variety or certainly differences in outcomes in those justices than on the left, where I'm not saying that they're purely results oriented, but whether they are pragmatists or progressives of some stripe, or living constitutionalists viewing the Constitution as evolving with the times, or Justice Breyer talks about active liberty and his kind of theories there. But in the most controversial cases that get all the attention, the Democratic appointed justices all end up in the same place. And you can't say that for the Republican appointed justices. Now, what does that mean from the perspective of liberty, or who do libertarians like? It really depends. On the whole, probably Justice Gorsuch is the best one, the one that most agrees with Cato's positions. Before him, it was Justice Kennedy for very different reasons. I don't think Justice Kennedy is a libertarian. It's just the way that his peculiar view of the world of the law ends up in a libertarian situation on net.
He seemed kind of like ideologically maybe more aligned with like a libertarianish kind of Democrat, like Jared
outcome, not necessarily in his theory, but in outcome. That's just the way things ended up. So the court is generally decent from a libertarian perspective. I mean, the thing is, the court is not a self-starting institution. It's not going to, in one fell swoop, implement, my or any other person's theories of the Constitution. They take the cases as they come. And they need, after all, 5 votes. It's not any one person trying to put something into place. So, people, whether they're happy about the state of the law or unhappy, it takes decades to transform where we're going in any given area. And so change is not going to come overnight.
So, what's your opinion on the nomination of Amy Coney Barrett? Do you think that she'll remain principled and ground her decisions on the basis of precedent like her predecessor? Because, I mean, Ginsburg, at least compared to a lot of other liberal justices, was relatively constitutionalist, like at least in comparison. But in terms of Barrett, do you think she's going to be more like that, or more like, or slash traditional conservative, or do you foresee her sort of veering more towards judicial activism, like a lot of people on the left are afraid she is?
Well, it depends how you define judicial activism. I mean, activism at this point is kind of an empty term that just means I disagree with your opinion, or I disagree with the judge or justice. I don't think she's going to simply implement her own policy preferences. You see that from her academic writings. You see it from her writings on the Seventh Circuit. She's a very strong originalist. Her mentor, the late Justice Scalia, for whom she clerked, I think was an influence on her, and she'll be somewhere between a Scalia and a Thomas. In fact, kind of the Scalia-Thomas dichotomy might be similar to the Barrett-Gorsuch dichotomy going forward. We'll just have to see. But how you originally phrased your question was with respect to precedent, and I don't think that's necessarily the way to look at things, because it's not always right to maintain precedent. I don't think it's always right to overturn precedent. It's kind of a prudential consideration. And the whole idea of stare decisis, I think, other than Justice Thomas, there are justices that would vote to keep precedent they think might be wrong, out of the idea that it's sometimes worse to disrupt society by correcting that long-standing error than to leave it in place, and leave in place kind of the institutions and expectations that have grown up around it.
So, from your perspective, what would you say the most significant legal victories were during Donald Trump's presidency? And also, what do you think that the biggest defeats were in terms of, again, sort of the advancement of liberty?
Espinoza versus Montana last term was a big school choice case that I think will be seen as very important. In that case, there's an opinion written by Chief Justice Roberts, a 5-4 opinion, and basically removed the last federal constitutional obstacle to the expansion of school choice, which I think is the civil rights issue of our time. There still could be state constitutional or other state issues, but mostly it's now a policy issue, a political issue in the different states. I haven't thought about the Trump era because, of course, the justices that he's appointed have only been on the court, not a very long time. So it's still kind of, when you think about the Roberts court, since Chief Justice Roberts became Chief Justice 15 years ago now, Citizens United is certainly important, but not as important as some people think, whether those that like that opinion or don't. I think independent political speech is and should be free, but money does not determine who wins in politics, and we should hardly want the government to be deciding winners and losers on the in the marketplace of ideas. One place where the court, I think, has been derelict is in not fleshing out its Second Amendment jurisprudence. After deciding that the Second Amendment protects an individual right to armed self-defense in the Heller case in 2008, and 2 years later in the McDonald case, applying that to the states, it hasn't fleshed that out, the scope of the right. And so the Second Amendment means different things in different places. I do think that it should, and it will very likely, take up a Second Amendment case just to give guidance to the lower courts that have been every which way in deciding that very controversial and important issue.
But yeah, you just mentioned the Second Amendment cases. I just wanted to illustrate this because I find it kind of ironic. So you had back during the Obama administration, you had a lot of people on the right who were afraid that he was going to end up severely restricting the right to bear arms and institute, you even had people who were saying he's going to ban guns, which of course is sensationalist. But I find it kind of interesting how those people went on to support Donald Trump, yet Donald Trump also did more to restrict Second Amendment rights than Barack Obama, specifically with his bump stock ban back in, I think it was 2018.
Yeah, and the problem with the bump stock ban, I think, is how it was done. It was done by reclassifying bump stocks, which is a tool that can be used to help people pull the trigger more quickly, to reclassify that as a machine gun, as an automatic weapon, which it doesn't. Which I think there's administrative law problems with that. If Congress had tried to do that legislatively, I think there would have been less of an issue. But you're right, and it's funny that the Obama presidency, while not restricting, most, let's just be clear, most gun regulation is at the state and local level anyway. So it's I think it's overblown how much the president or even Congress does in this area. But the Obama administration was a boon to gun manufacturers, and the Trump administration has, as you said, put in more restrictions really than Obama did. But the real problem we're living is that the Second Amendment means different things in different parts of the country, and that's totally the fault of the Supreme Court in not making that clear. How not even which kind of restrictions or regulations are okay, but how to evaluate a given regulation.
Exactly. But so this one is I don't want to say this this question's not particularly off topic, as it kind of has to do with what you said in the beginning about infighting between libertarians, because there's a lot of different. It's really a particularly big tent movement. Like, you have everyone from minarchists to ANCAPs to classical liberals, which I think you and I would probably consider ourselves. But in 2 weeks, I'll be having economist, pretty controversial, but economist and libertarian theorist Walter Block on my channel for an interview. He takes some pretty controversial stances with regards to what he believes should be permitted in our legal system, such as slander, libel, and indentured servitude on the basis of voluntary contracts. I'm going to be asking him about that. But those are, to say the very least, very radical positions. And hypothetically speaking, at least from a logical perspective, would you say that those are compatible with the principles of a truly free society?
Well, I think slander and libel is damage to someone's reputation, and
Yeah, I would agree.
And I think that is harming someone. It's properly considered a tort, just like punching someone. I'm free to swing in a kind of under classical liberal theory 101. I'm free to swing my fists until that gets to the point of your nose.
Similarly, harm principle, like John Stuart Mill.
Right. I'm free to say things until that harms you in various ways, and so. There's no First Amendment protection, rightly so, for libel or for fraud, for that matter. If I, with my words, cause you to give me, a lot of money for something that I claim to be as a valuable commodity and it really isn't, well, I've defrauded you, and I'm not protected just because I haven't done it at gunpoint. I've done it with my words, but still, I don't think, the right to freedom of speech should be a defense. So. Some of these ideas are too radical for me, but I'm a constitutional lawyer. I'm not a philosopher, libertarian, or otherwise.
Okay. So what is so this is a question I kind of added last minute, because I know I contacted you before any of this happened. But what is your opinion on the Trump impeachment? Do you think that he engaged in sedition back on the events of January the 6th? And also, with only 5 days left of his presidency, should he be convicted and removed? And is it even worth it at this point, seeing as he only has such a short time left in office?
Right. Well, the second one is really two different questions. That is, out of principle, is it impeachable? And then, should he be impeached as a matter of prudence because of the time, what have you? The first question is, what did he do, and does that rise to the level of a high crime and misdemeanor that is an impeachable offense under the Constitution? And I think you take his speech on the Mall on January 6th in the context of having, whipped up a crowd and told certain things to preserve this idea that the election was stolen. And, if you really believed that the election was stolen by, XYZ, the elites, the Democrats, Republican establishment that were in cahoots with them, all the rest of it. And you felt that, everything that's good and true and pure that you love about your country is going to be lost if this steal is allowed to happen. What would a good patriot do? right? So I think inflaming the crowd in that way, and this is not a matter of debating the legal technicalities of incitement or insurrection. Those are legal terms of art, but that doesn't matter because something doesn't have to be a legal crime to be an impeachable offense. So yes, I do think that Donald Trump's behavior, and I probably wouldn't have written the impeachment article exactly in the same way that the Democrats did. They were still playing their own political
I
games.
think that's what
Thomas
Massey said too, because I think he voted president.
Yes, yes, yeah. And so did Andy McCarthy, who's generally a Trump supporter, but he said he went even further than Massey. He said, yes, Trump definitely committed an impeachable offense. Here's how I would have rewritten the articles to make that so. But anyway, so out of principle, I would vote to impeach Trump. The question is does it serve any purpose to do it this close to the inauguration day? Yeah. And the purpose is to make a statement that there's not some time where if you come so close to the end of your term, at that point you can do anything with impunity. Well, no, I think Congress has to step up for itself there as well. Plus, there's the issue of the remedy of disqualification. So impeachment is not simply about censuring whoever its target is or removing from office. It's also about disqualifying from future office. And that's why we're about to have this debate. We are having this debate of whether a former official can be properly impeached or properly convicted by the Senate. And there's a prominent debate cutting across ideological lines in our op-ed pages by academics and others going on now about that. I think that because there's this remedy of removal, as well as the desire to have a prophylactic mechanism there for public officials, not just the president, to be punished or reprimanded or impeached or what have you, even in the last days of their term. I think those who say that he can be disqualified as a former official probably have the better of the argument. But that's what we'll be debating in coming weeks.
Okay, so what reforms would you? And we're sort of starting to come to the end here because I know you're a bit short for time. But what reforms would you like to see made on our Supreme Court system, whether regardless of the ones that you propose in the book or other ones that you did not have time to propose in your book?
Well, I didn't really propose much of anything. I sort of, I'm amenable to having term limits for justices because then at least you'd get rid of these morbid health watches for octogenarian justices or politically timed retirements or kind of arbitrary vacancies when they happen. And that would instill greater confidence in the court, but it wouldn't change the substance of what the court's ruling on or the importance of those justices, even if they're serving for 18 years instead of 25 or 28 or what have you. Because the real issue isn't all of these reforms that are dealing at the margins of whatever's going on with the court. That's rearranging deck chairs on the Titanic. The Titanic is the ship of state. And fundamentally, it's this dynamic that I opened with the court being important, ruling on important things, and having these divergent theories of interpretation. And so in the long term, the only way to fix this dynamic or to lower the heat on judicial nomination confirmation battles is to have the court rebalance our constitutional order, put decision-making back to the local and state level, and within the federal government, force Congress to make political decisions rather than punting them to the administrative state. Now, we're not going to get there overnight. It's not an easy thing to do, but it took us decades to get to where we are in the first place, and it's going to take decades to unwind.
So I have one final question. This is more of like a hypothetical proposal. A lot of people in my audience and people who've come onto my live streams before, because we've talked about this very subject. We had an entire stream on the Supreme Court in addition to one that was covering Ginsburg's death. But we were floating around ideas about ways that the court can be reformed, and we settled on this potential one. So most of us were in agreement. It was mostly libertarians, and then we had a socialist on there too. We were talking about how it seems like almost a conflict of interest, at least with how much the executive power has expanded over the past 200 years. it seems almost like a conflict of interest that the president is the one who who appoints Supreme Court judges. So we thought of another solution. So you have very similar to how the Pope is selected. Whenever a Pope retires or dies, you have the cardinals that come together. They end up deciding, like 2/3 of them, they decide on who the next one, like the white smoke and everything. So what if it was similar to that's how Supreme Court justices were nominated, but instead, of course, of cardinals, it would be all the federal judges get together, and 2/3 of them have to vote on who the next justice is. What do you think that could be a viable solution? And if not, what would be some criticisms of that?
That one I have never heard. I've come across a lot of proposed constitutional reforms or Supreme Court reforms. That's the first time someone's asked me about that one. It would take a constitutional amendment, first of all.
Of course, yeah.
That's interesting. That's very interesting. Yeah, off the top of my head, I don't know what I think about it. Have a 2/3 requirement. Well, what happens if they can't agree? I guess you just keep the vacancy. I'd have to think about that some more. I'm not prepared to just give a yay or nay.
Okay.
That's very interesting.
Yeah, I was just yeah, I mean, a lot of us, we consider ourselves like basically lay theorists. So,
yeah.
But so finally, what is
I do know that there's a proposal called a College of Justices. Speaking of the College of Cardinals, but
okay.
Where there are no permanent justices, and instead they're selected at random to serve for a short amount of time from the existing federal appellate judges. But then you run into the problem of, well, the way that the probabilities work, you could have a 6-3 or even a 7-2 of Republican appointees to Democratic appointees, or vice versa. What's the legitimacy there? They have more zigzagging of jurisprudence from constantly shifting body, things like that. So I'm generally opposed to that kind of an idea. But what you're proposing is a very different kind of College of Cardinals, College of Justices. So yeah, I'll have to study the issue.
Oh, well, thanks for commenting on that. Never got a chance to ask a legal expert that question. That's something I've kind of always wanted to ask. But so finally, what is the elevator pitch for your book? Why should people read Supreme Disorder?
We get vacancies fairly regularly, and every time it happens, everyone goes to DEFCON 12 in Washington. And so to understand how we got to where we got, the issues at play, and how you should be thinking about both the jurisprudence and the selection process, that's what my book gives you. And also, if you're a history buff, there's quite a bit of that.
Oh yeah.
If you're a political buff, there's some of that. If you're into legal jurisprudence and you want to learn about that, those are kind of the three aspects that my book covers. And so I think there's something for everyone.
You start all the way back, I believe, in the 1790s.
I started what my book, like Gaul, is divided in three. The first part, which I call the past, runs from George Washington to 1968 to LBJ, as I discussed. The second part, what I call the present, is Nixon, or 1968 through Brett Kavanaugh. And then the third part, the future, is lessons learned, reform proposals. Where do we go from here? So I think it's written in an engaging manner, definitely accessible. You don't need a JD to understand it. That's not the market. But by the way, anyone who buys it, I'm happy, given that I can't do in-person signings other than when I pop by the Barnes & Noble and sign the books on the stacks there. But I'm happy to send a signed book plate to anyone who buys it.
Thank you so much for coming on and chatting with me for these past, it was about 30 to 40 minutes. I didn't check the time, but yeah, thanks so much for coming on. Really great to have you. Again, everybody, Supreme Disorder, available in hardback now. Please support brick and mortar bookstores. Only go to Amazon if you need to.
Right. And also available on Audible, also available as a Kindle book. And for that matter, speaking of bookstores, brick and mortar, whether Barnes & Noble or independent or what have you, if you go to supremedisorder.com, not only will you find various links of where you can buy it, not just Amazon, but you can download for free a 20-page statistical historical appendix, so you can really nerd out and be popular at your next virtual cocktail party.
All right. Again, thank you so much for coming on, Mr. Shapiro. Stay safe out there, and I hope you have a pleasant evening.
You too. Take care.